I'm very happy to welcome all the participants on behalf of IPNet and request Ms. Suhasini Ashok B, Regional Head South, to present her welcome address.
Yeah, good evening. Good evening, everyone. On behalf of IPNet Southern Region, I'm delighted to extend a heartfelt welcome to each one of you to today's webinar titled Managing Personal Insolvency Cases and Launch of SimplEase. As many of you know, this webinar is part of series organized periodically under the auspices of IPNet. This is a national network for insolvency professionals. So today's session is being hosted by IPNet South and is aimed at fostering insights and discussions on this critical topic. So without further ado, I hand over to Brinda ma'am. Thank you.
Thank you, Suhasini ma'am. Now we have a short IPNet introduction video. Can we have a video cue?
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you. Now I request Ms. Anu Bisani to introduce our chief guest, Mr. Rajesh Sharma, former technical member, Honorable NCLT. Mr. Rajesh Sharma.
Thank you, IPNet, for this opportunity. It's my immense pleasure to introduce Sri Rajesh Sharma, former member NCLT, where his proficiency in insolvency and bankruptcy law is quite evident. His bench at Mumbai disposed of more than 2,500 cases of IBC and Companies Act in a span of total 500 days of sitting, thereby giving an average disposal rate of 5 cases per day. It's a big achievement, sir, on his part, and this must be one of the highest disposable rate among all NCLT benches across India. He is a recipient of most prestigious national award of ICAI, CA member in Public Services 2022. He is a fellow ICAI and MBA Finance from the Faculty of Management Studies, FMS, University of Delhi, apart from postgraduate in Commerce and so on. He has also held pivotal positions as the Chief General Manager at the NHAI, as the CFO of HSIIDC, and as Director General of the Services Export Promotion Council of India, Ministry of Commerce and Industry, Government of India. Over his 33 years career, he has excelled in various insolvency and bankruptcy law, NPA management, finance, economics, accountancy, industrial management, and corporate governance. He is a sought-after speaker at national and international conferences and has been actively involved in government and non-government committees and delegations. His extensive global experience is evident through his travels to various countries, enriching his perspective. He is one of the distinguished professionals in the country who is having end of projects to resolution or dissolution of the corporates. His YouTube channel, Insolvency Veterans, is quite popular, where he discusses IBC and corporate law with luminaries like Supreme Court and High Court judges, former president and members of NCLT and NCLATs, etc. So I request all of you to please join me in welcoming Mr. Rajesh Sharma. Thank you so much.
Thank you very much. Thank you.
And sir, before you start, I have a small request to make to all participants here. Friends, can you open your videos? I think it will good. We'll also have a screenshot or a picture. And I think smiling faces is very important for all us to see. So over to you, Sharma ji.
Thank you very much. Thanks for the nice introduction. And thanks, Ashish ji, for inviting me in your webinar. You know, I'm really delighted to discuss a very, very important topic today with respect to personal insolvency under the IBC 2016 and role of technology coupled with efficient case management in empowering the insolvency professionals. I hope majority of the participants are insolvency professionals, and I don't think I can, I can give you more knowledge what you people are already having in the field. When we talk about insolvency, you see, we try to basically involve with us because the insolvency as is it present today, it has its root from British law. Before IBC 2016, we had SICA Act. Before that, we were having, or rather, some part of that is still we are having the Presidency Town Insolvency Act of 1908, which is applicable in Bombay, Madras, and Calcutta, that is presidency towns of those times, and the Provincial Insolvency Act of 1920 for all the towns and the entire India except Bombay, Madras, and Calcutta. Before that, we were having Indian Insolvency Act 1848, which has its roots in British law. I think we start with this and we reach to IBC 2016. You see, that is right that these acts and laws may not be that old, but insolvency as such is not limited to British law, from where we try to find out our law. Insolvency in India is from ancient times. You see, I tried to trace the insolvency law in India during ancient times also. And I have written an article on this. I'll share it with the organizers to be shared with all of you in due course. While tracing the insolvency laws, I could not find anything during the Satyug period where we have our lords Brahma, Vishnu, and Mahesh, and so on of that time. And I could not find anything in that period of Satyug. However, from Treta Yuga onwards, I was able to trace a few instances of insolvency law, and I can very well say that it was well developed even during those periods when we were not even thinking of insolvency, and we just try to tag ourselves with British law. You know the well-known story of Raja Harishchandra during Treta Yuga. It has similar to corporate insolvency as well as well as personal insolvency, which was prevalent during that period also. As there were no corporates during that time, we can very well relate it with the kingdom of the king, which we can make a similar thing to these days corporates. With his Rishi Ran, during those time also, there was a concept of loan, concept of rin. Rin was Rishi Rin, Rin was Raj Rin, and Rin was Pitra Rin also. Raja Harishchandra, when he was not able to, pay his Rin to Rishi, he surrendered all his kingdom, that is the corporate, to Rishi in his favor. And when he was not even able to discharge his liabilities towards that Rishi Rin, he sold himself, his wife, and his son, and finally became a servant to Chandal. During the Dwapar Yuga, we have a well-known case of Dharmaraj Yudhishthir, where he lost everything in gamble, and later on he had to at that time there used to be the concept of selling yourself and your family also to repay your loans. After that, in Kali Yuga, we have a lot on insolvency from Chanakya period, where in Kautilya's Arthashastra, he has dealt with the issue of insolvency during those periods. Kautilya Arthashastra is having a detailed discussion with respect to insolvency, and you see, you will find a few words during those period also, which is called Kudisan. Kudisin is the creditor of the of nowadays, and there used to be Vyavarik, who is akin to you resolution professionals of current days. Vyavarik used to, basically collect the entire data with respect to the insolvency, and were used to find out as to how the insolvency can be resolved. There were conditions with respect to the maximum amount of interest that can be charged by the creditor. That is Kudisin of that period. There was a concept of Dam Dupt. It means your interest, levy of your interest cannot be more than your principal amount, so as to give a level playing field to the creditor also, so that he is not burdened too much of interest with too much of interest. During the Mughal period also, we have cases of insolvency where we find, in Kautilya period, we have the concept of Ran Patra, Ran Panna, or Ran Lekhya, which is lease, which is loan documents as of date. We have the concept of bills of exchange, as well as DP and DALC. DPLC used to be called at that time the Dastavez on demand, which used to be called Dastaved Intula during the Mughal period. And DALC used to be called like Dastavez Miyadi. Miyadi means period. DLC. There used to be Nazir. There used to be Qazi ul Qajat, who used to be Chief Justice like position. So that way, discussing with you all these things, I just wanted to impress upon that let us not restrict our insolvency system only to the Britishers, that they have given it to us. It used to be with us for a long time, and rather from our ancient times, in different names, different times, but the concept was very much there. Now, coming to the present day situation, we all are aware that it is in part 3 of IBC 2016, which is yet to be notified for proprietorship, partnership, and individuals. However, for the corporate debtor to the for the personal guarantor to the corporate debtor, it was notified in 2019, and we have a series of cases where this jurisprudence has developed. Now, I think it is a settled law that with the Supreme Court orders and all that, that the personal insolvency can be well dealt along with the corporate insolvency, where the corporate personal guarantor is the guarantor for corporate loan. It has also been settled now in so many cases that there is no need of having a case pending against the corporate debtor in advance before admitting the application of the personal guarantor. With this, I'll close my remarks, and during the passage of time, if we will be having some questions, we'll be dealing with it. Thank you very much. Thank you.
So he has written an article.
Yes, I have written an article in case you don't have.
Like the journal, I think that is the same thing he must have talked just now.
Yes.
Here also there was insolvency, Chanakya, Ganakya, and
all those things are, most of the things are there. Right?
Our camera is off on our chips.
Okay, Brindaji, can you take over now?
Yes. I thank you so much, sir, for the insightful view on the personal insolvency. It will help us in our future deliberation. Now I now invite Dr. Ashish Makhija, President IPNet, for launch of SimplEase by Chief Guest.
Okay, thank you, Brindaji. Friends, I think this is a very important moment. Mr. Rajesh Sharma, I think you see, former member of NCLT, I think he deliberated and you see went into the history and gave us the historical development of insolvency. So insolvency, my dear friends, is not the you see, you can say the current law, but it has got its roots long time back. So that is what he wants to emphasize. But now, what is important, my dear friends, is that all of us are typically involved in personal insolvency. Of course, we have been doing CIP matters, we are doing liquidation matters, but then insolvency, personal insolvency is typically a new subject. Now, how to do with that, how to go with that, the transition has come out with you see, a product which is known as SimplEase. We will definitely, you see, learn about that. But right now, may I request our chief guest, Mr. Rajesh Sharma, to please, I think he should be, I mean, we'll be very delighted that if he launches this product, which is known as SimplEase, which is a personal insolvency case manager. Sir, if you can do the honors, please.
Yeah, I'll do that. And you see, I'm trying to combine these two things. What we know about insolvency in the ancient times and even today, and where the technology can take us further with respect to insolvency. You see, case management and technology. These are the two things with which we all have to be convergent, and very well hands-on experience of these technological changes, will be easing a lot of our personal efforts in case of dealing with the personal insolvency. I'm really happy to launch this SimplEase, which is a step further in this direction.
Thank you, sir. Can we have the video, please?
As a practicing insolvency professional, you know there's no room for error. One mistake could derail an entire case. But with endless paperwork, constant back and forth between legal texts and spreadsheets, how do you ensure everything is in order? That's where we come in. Introducing SimplEase, the ultimate solution designed to revolutionize how you manage personal insolvency cases. SimplEase streamlines the entire process, offering auto-generated timelines aligned with the Insolvency and Bankruptcy Code (IBC), ensuring every compliance step is tracked with precision. Its step-by-step guides break down complex insolvency procedures into manageable stages, providing clarity and confidence throughout. SimplEase also includes ready-to-use templates, section-wise legal provisions for quick reference, and comprehensive checklists, so no task gets overlooked. With SimplEase, you can save valuable time, minimize errors, and deliver top-notch outcomes for your stakeholders. It's time to work smarter, not harder. Let's make personal insolvency case management simpler, faster, and error-free. Choose SimplEase by Transition.
Thank you. Friends, I think we are very fortunate that Mr. Rajesh Sharma has launched this. Friends, I'll just give you a small overview, but before that, can we have that walkthrough video just to showcase what exactly it deals with? We have two walkthrough videos which will take you, because this is a one single you see software or application which will actually take you, which will take your case, compliance and everything. And probably you may not require any person in your office to do that. It can be done by a simple one person. So can we have this video, please?
Welcome to SimplEase PI Case Manager, the ultimate tool for managing personal insolvency cases effortlessly. In this video, we'll guide you how to add a new case that will help you streamline your case management. Adding a new case in SimplEase PI Case Manager is quick and straightforward. Click Add New Case on the dashboard. Enter the case details such as case reference number. You can assign a unique reference for easy identification. Case status. Here you can choose the appropriate status. Stage 1 is initiation. Select this if your case is in the pre-admission stage. Stage 2 is admitted. Choose this if your case has been admitted by the adjudicating authority. If you select stage 1, enter the case filing date. If the case is already admitted, simply select the NCLT bench and proceed to the next step. Here enter the details of the resolution professional, including name, email, contact details and IBBI registration number. If the case is admitted, you will be required to enter the appointment date of the RP. Otherwise, proceed to the next step. Here enter the debtor's details, including name, email, contact details, and name of the corporate debtor for whom the personal guarantee was given. Review all details carefully before submitting, as the case filing date and RP appointment date cannot be modified later. And that's it. Your case is now successfully added and ready for management in SimplEase PI Case Manager.
Okay, friends, after this, once the case is created, then of course, there are editable templates. There are a lot of other videos. We're just going to show one more for editable templates. Yes.
Welcome to SimplEase PI Case Manager, the ultimate tool for managing personal insolvency cases effortlessly. In this video, we'll guide you through the editable templates. On your case screen, you'll find the AI-generated timeline, which outlines the steps you need to follow during the personal insolvency resolution process. For each step, you may require forms, templates, applications, or formats. Finding these documents online or creating them from scratch can be time-consuming and challenging. But with SimplEase editable templates, you no longer have to struggle. You'll find that templates are automatically pre-filled with the details you entered during the case creation process. Simply select the text to add, edit, or remove information as needed. Adjust text formatting, headlines, and layout to meet your specific requirements. Once you've made the necessary modifications, your time and effort. With SimplEase PI Case Manager, instant document generation and editable templates make insolvency case management easier than ever. No more searching for templates, just review, modify, and download effortlessly.
Okay, thank you. Friends, I'll just give you a very brief background of this. Imagine you are handling a personal insolvency case. Now, you know that there are multiple deadlines, there are compliance requirements and legal formalities at every stage. And you have to switch between the regulations, the templates, the form, and one misstep can lead to a major complication. So therefore, friends, this is where you see exactly the SimplEase was created now to make the personal insolvency case management absolutely effortless and foolproof. Now, this is an intelligent case management platform which will do the heavy lifting for you. Now, how it will do? Number one, auto-generated timelines. You just simply add the date of your appointment. Now you will know exactly what you need to do at each step with absolutely clear deadlines. Then, friends, the process guide. In fact, I have been involved in creating the process guide for every step. You do not go or scramble through different sources. Everything is structured. At the press of a button, you will have your guidance. And then you can also access, like you want to see section 108, you want to see section 94, you just press that, you will actually, the section will be displayed, the latest one, the rule, regulation, forms, they will open in separate windows. And then, of course, as we just saw, there are pre-built templates and checklists which are there. And of course, if you find that some template is not there, you can raise that question and a template will be provided. So it will be updated on a constant basis. This is a dynamic kind of a software which is there. And then the case management is categorized into two parts: pending and admitted case management. So you can track your progress. You have not been appointed so far, you can track in a pending case. The moment it is admitted, then definitely you can change that to admitted. So friends, SimplEase is not just a tool, it's your virtual guide. And if you're dealing with insolvency cases, personal insolvency cases, you want a stress-free way to manage them, well, SimplEase is the answer. So friends, I think you can just explore. The link will be available on the chat box. You can go and explore that. So now I will just end it there. I must thank, from the bottom of my heart to Mr. Rajesh Sharma for giving us the keynote address, a wonderful keynote address, and also for launching SimplEase, which is one of the important case management software by transition. So I think over to you, Brindaji. So for the further for presentation of memento and other things. So please go ahead.
So here's a memento for the Rajesh sir.
Yeah.
Thank you so much, sir.
Yeah, Rajeshji, we will deliver this physically, but we will request with folded hands to accept this virtually on our behalf and on behalf of the IPNet family here. Thank you so much, sir.
Thank you very much. Thank you. Thank you.
Thank you. Thank you so much. Now, I now invite Ms. Geeta Sridhar for introduction of our lead speaker, Dr. Ashish Makhija. I also announce that Ms. Rasmi Chaucharia will be the moderator of this session.
I think, Brindaji, we can skip the introduction because I think most of the guys know me, so I don't need you see any introduction. I'm simple introduction is Geetaji. You can just read it very quickly.
Very good evening. As Makija sir said, Dr. Makija wouldn't require any introduction because we all know him pretty well. But then for the convenience of other members, let me introduce him quickly. It's my pleasure to introduce Dr. Makija sir, a distinguished legal expert and the president of IPNet, specializing in insolvency, bankruptcy, and corporate laws. With a career spanning over 3 years, Dr. Makija had represented clients across Supreme Court, High Court, NCLAT, NCLT, and numerous arbitral tribunals, establishing himself as a leading authority in his field. Dr. Makija is a highly accomplished academic, holding a PhD in law from Emory Law School in the USA, dual LLMs, including one in international bankruptcy, and qualifications as a chartered accountant and cost accountant. He has also served as standing counsel for the official liquidator at the Ministry of Corporate Affairs, where he was attached to the Delhi High Court for 6 years. A prolific author with many books, including the widely respected Insolvency and Bankruptcy Code of India. Dr. Makija is also an adjunct faculty at the Indian Institute of Corporate Affairs and a prolific speaker. His contributions extend to key committees and working across that shape corporate governance and insolvency practices in India. Please join me in welcoming Dr. Ashish Makija.
Thank you. I think Rashmi ji is there. Is Rashmi there?
Yes, sir. Yes, sir. Yes, sir. I'm there.
So you can start and then I can take over.
Yes, sir. Thank you, Brinda. Thank you, Geeta ji. It's a great privilege to moderate today's session on personal guarantors with none other than Ashish sir. We have been connecting with sir on the personal insolvency study groups of IPNet, and it's now a webinar on the specialized topic personal guarantors. Thank you, sir, for this opportunity. And as we all know that PG assignments have started in full flow in NCLT, and so are the confusions with recent orders. I would like, sir, to guide us, as we all know that there is no particular format for the PG report. What all are the points which has to be kept by the resolution professional while drafting Section 99 report? Whether he needs to see the Limitation Act, the forum in which application is filed, it has to be DRT or NCLT, whether all these aspects needs to be covered by the resolution professional while admitting a case on personal guarantor and his Section 99 report. And there are plethora of recent judgments which has created confusion in the forum that this case needs to be not admitted because it is there's no CIP pending. So I request you to, sir, all these, just to cover them. And then can RP reject on this ground admission of case in a Section 99 report? Limitation Act may, what will be the date to be considered for invocation of guarantee? We all see that there are, it is 20 years back cases are coming right now. CRP has ended, resolution has done. Again, just because of the follow-up letters, the bank is initiating a Section 95 application against the PG. And how can PG admission be boon to personal guarantors? I would also like, sir, you can just give aspects to personal guarantors. They are in such a difficult situations once that it is admitted. They cannot just start their own show. We have seen cases in Calcutta that personal guarantor is living in a lavish flat. Lot of responsibilities are there pertaining to his corporate debtor. The kids are studying in high schools, in very good schools where the fees are very high, and the personal guarantors have transferred all their assets to her spouse. So what are the IPs? How to take custody? So all these are practical difficulties which we are facing. And then suppose CD has 3 financial creditors, and all 3 FCs have initiated PG cases. So what has to be done? And most importantly, sir, PG's fees, personal guarantors fees. We RPs, very struggling because now the NCLT demands personal appearance of RP in all the cases in NCLT. So, and legal fees is to be borne by nobody. Nobody's coming there to, bear the legal fees, not even the financial creditors. Only the fees which is mentioned by the NCLT order. And that too is different in every state. Calcutta is mentioning something else, West Bengal Calcutta NCLT, other NCLTs are mentioning something else. So what is to be done? If you can just take off all these questions and post admission, like if no repayment plan comes to RP, what does RP needs to do? And if money is recovered from the PG and the CD goes into liquidation and then the proceeds are recovered, what are the options available to personal guarantor regarding his recovery? So how to take custody of PG? What are the yardsticks available to the RP to identify the personal assets of PG? As normally they do not have the balance sheet. When we ask the personal guarantors to produce, they only say that I have been filing my income tax return. Only with the PAN, how can we detect, what are the assets which are there? So, sir, your comments on these insights will be very helpful for us, sir.
Okay. Thank you, Rashmiji. I thought there will be 2, 3, 4 questions. I think there are a lot of questions which needs answer. I can recognize that and I appreciate that. Friends, let us begin in the right version. Number one, today it's not going to be a kind of a lecture where I just speak and go back. Today we are going to cover the questions. So if you have any questions which come to your mind, maybe you can put it in the chat box. So Rashmi ji will definitely take it up. She has already given me a whole list of questions to be answered. So let me start one by one. Friends, as we are aware, now I think let's go back and look at the history also. Of course, I'm not taking you back to the Indian history, but history of IBC. Section 2, which talks about application of the, application of IBC was amended in the first ordinance. And everyone is aware that the first ordinance came on 2017. Now, the first amendment which was brought in, of course, we know that 29A was introduced, but along with that, in a very, you can say in a very brief manner, Section 2 was also amended. Section 2, which typically talks about applicability, now it was amended in what way? The clause number E, which was there, that was broken down into 3 parts. Clause number E initially read as partnership firms and individuals. So that was applicable to partnership firms as well as individuals. Now, what it was broken down into? Now the clause number E now reads as personal guarantors to corporate debtors. And clause number F reads as partnership firms and proprietorship firms. So even proprietorship firm word was also added. And then clause number G talks about individuals other than personal guarantors to corporate debtors. So friends, individuals were actually divided into two parts, those who are personal guarantors and those who are not. Now, what was the purpose of doing that? The purpose was, I think most of my friends will recall that earlier there was a confusion whether the proceedings against the personal guarantors can continue in DRT while the company is under CIRP, whether the moratorium under Section 14 will apply to the personal guarantors or not. Well, this was answered by Supreme Court. The Act was also amended. Section 14 was also amended. But at the end of the day, the central government realized that, look, the debt is same, the default is same. So therefore, the personal guarantors cases should also be dealt by the same forum. Because if personal guarantors case go to DRT, then they will not be, because if the CIRP is pending or liquidation is pending, then the case is going somewhere else. So typically they wanted that personal guarantors cases to also come to the same forum. So therefore, in a phased manner, my dear friends, clause number 2E was notified. Clause number F and G still remain to be notified. That means partnership firms and in other individuals. So along with that, the government also notified part 3 substantially. When I say substantially, means all sections were notified except the fresh start. So from section 80 to 91, 92, they were not notified. So all other sections were notified, including definitions, everything. So bankruptcy, also insolvency, also for personal guarantors to corporate debtors. So now, my dear friends, we have two sets of rules where you can move an application. You can start, the rules are typically for filing an application. And then we have got two sets of regulations, one for insolvency and one for bankruptcy. Having said that, now most of the cases have been coming and they are pending. I think a lot of my friends have been appointed and some of them are still pending for admission. Initially, they were pending because of the Supreme Court. You see, the stay was there, and that stay was removed. And the judgment of the Dilip Juarika judgment, which came, I think we are all aware. First, there was a quarrel whether this can be notified separately by the MCA or not, which was done by the Supreme Court in Lalit Kumar judgment. They upheld that, and after that, Dilip Juarika, whether a notice must be given to the personal guarantor prior to admission under section 99 or not. So whether they should be heard prior to the report of the RP or they should be heard later, then Supreme Court said nothing doing. We will hear you only once the report of the RP comes. So now here, friends, one more aspect which is important. I think most of us are aware. This is quite different from CIRP. In CIRP, RP is not involved at the time of the application. The RP or IRP comes into picture when the case is admitted. So your role starts only at that time. And in case of resolution plan, RP has no role. RP has role once he receives that, plans, he has to examine it and verify it and then place it before the COC. So that is the role which the RP plays. And then in implementation, he may or may not be a part of the monitoring committee. So our role typically is restricted to the process. But in part 3, in personal insolvency, friends, I always say that the RP who is appointed is a friend, philosopher, and guide of the personal guarantor or the individual in case those provisions are notified later on. So you will be involved the moment the application is filed. The application can also be filed through you, or two, if it is not filed through you, you may be appointed to examine and also assist the court by saying that whether this application should be admitted or not. Let's imagine this. In fact, I had suggested to the government, and it's a very good idea, the moment a CIRP application is also filed under section 7, 9, or 10, or 9 particularly, even at that time, you can appoint an IP, take his assistance, take his report, recommendation. So here, the task of the NCLT will also get reduced. And we are, as IPs who are professionals, who are experts in this area, can typically file our report whether this is admissible or not. Of course, the final decision rests with the NCLT adjudicating authority, but at least we can assist. And this will actually expedite the process further. So anyhow, those suggestions are being considered. We don't know whether they will be implemented or not. But having said that, here there is a recommendation. So once you give a recommendation and the report. So now we'll talk about the report first. Once you are appointed and you are given a copy of the application, your task begins from there. There are 2-3 aspects, friends, which you must take care of it. And what are the points which have to be kept in mind while preparing then drafting such report? And one of the question which Rashmi ji has also asked is whether whether the RP should also look into the Limitation Act also or not. And there is no format also. That is also another important thing. So friends, I'll deal with these 3-4 aspects, very important. Number one, friends, as far as limitation is concerned, it is the duty of the RP to at least look into that, whether according to his opinion, whether in his opinion, whether it is within limitation or not. Of course, the final decision will rest with the adjudicating authority. Many of the IPs have spoken to me, and I've always advised in that manner. And I'm very happy to tell you that you see, last week, one of the our fraternity members, transition alumni, and other people, an IPNet member also, and he sent me a message. He said, "Sir, based on your advice, I left that to the opinion to the adjudicating authority, but I gave my opinion on limitation, and then the court considered that." So, friends, it is very, very important that you must really, really apply your mind whether it is within limitation or not. You have to just not simply say that rejected because it is outside the limitation. No, you will not be saying that. You will simply give your opinion and you will say that I'm giving my opinion for the matter to be adjudicated by the adjudicating authority. So as far as limitation is concerned, that limitation part will be decided by the NCLT, not by you, but your report and recommendation is extremely, extremely crucial. Now, the other part is there is no format. What should be done? By that time, I believe IBBI may come out with some standard formats, or maybe NCLT may establish some customary practices which will be there. But let me share my screen with you, because right now, you see, we can see that the transition has launched that particular, you see, software. Now, I just want to show, that is an important thing which I wanted to show, that what could the template look like. Now, look at this. This is the template. Typically, this is the initiation stage. So I've just opened that software. It's a test case only, and I will show you when you go. Okay, let's look at this also. I think most of the things will also be clear from here. Application by debtor through RP, of course, section 94, then these are the rules and this is the form. So these are all hyperlinked. You can just click 94 and the 94 section will open. And if you look at the checklist part, look at this checklist, view checklist. The moment you click this, my dear friends, a window will open with a complete checklist. Look at this. Now the checklist is before you. What are the documentations? What are the income and asset verification? How do you, supposing somebody comes to you, the debtor comes to you, he wants to file an application along with you, you have no idea. So here, this is the checklist which is being given to you, and it runs into, say, 2 pages. You can go to the next page. You can actually take guidance from this, and this will really, really help you that what are the areas which you have to look into this. Now, supposing you have to file that form number A, right, which is the form number A. Look at this. This is an editable template which the software provides you. The moment you open it, form A will come out this. And now it is an editable template, my dear friends. You can add, you can delete, you can change whatever name you want to do it. And then once you have done that, so this is a template, you can always change it. And after you're done it, you can download it in PDF and you can use that particular format. So these are the formats. So therefore, if I go to, you see the report under section 99, because I think the question was relating to the report. So let's go to the report by the RP. This is the checklist. What you need to look at it, how you will verify the default, how you submit the report. This checklist you must follow. If it is before you, my dear friends, I don't think you're going to make any mistake in this. And now we have got even transition has also given in this software like email to debtor. Supposing you are appointed for the first time, what is the first email you want to send to the debtor or the corporate or the personal guarantor? So you will find that editable template which will be there. So editable template is there. You can add, you can modify it as per your this thing. You can insert your name, everything you can mention it here. These are all editable formats. At the click of the button, everything. And you can look at this convenience. It is coming quickly. And then report by the RP, there is a format of the report which is also in editable format. Look at this, report by the RP. So there, the particulars of the matter, communication, compliances, whether you have seen those compliances under 99 or not, whatever the non-compliances, and then you can also recommend whether you are recommending or you are recommend for admission or you are recommending for dismissal. So I think those things will be there. And if you look at this, there are quick tips which are given. You can actually go through these tips, and then the process guide is also available for all time, like process guide for report by the RP. Supposing I click on this. Now this is a question answer format which comes. You can expand all of them. And then what if the RP requires legal or professional advice during examination? So the answer is available. What happens if the RP fails to submit the report within 10 days? The answer is there. Why is it important for the RP to record reasons for their recommendations? The answer is there. Who receives a copy of the RP's report? So whether you have to give it to debtor, creditor, all answers are there. And in fact, there is a search window, friends. If you want to search it, you can search it. I mean, you can very quickly find out. So for each step, there is a process guide, which is detailed process guide, which is available to you. And definitely, you see, you can look at the other full process guide if you want to look at. On the top, you can find it full process guide. Now, if I click that, this will be opened for all steps. And here, like supposing there is a search window, I say moratorium. I just want to know about moratorium. I'll just write moratorium. Okay, so let us look at moratorium. So all questions about moratorium, interim moratorium, everything is appearing out here. And you want to find out by section, like I want to find out for section 98 or section 78. Now all these questions which are there, so they will be made available if any, I mean, those things are there. So all these things are typically there. You can search it by any filter, by regulation, by rule, or whatever way you want to do it. Anyway, let me go back now. So the point is, what I'm trying to say is that as far as the format is concerned, my dear friends, the format is extremely crucial. And once you have done that, because there is no particular standard format, it will depend upon the facts of each case, because typically each case becomes very, very important, isn't it? So all cases are extremely crucial and they are different from each other. So therefore, it is very important that we can look into those kind of things. So anyhow, so friends, this is the way I think you are going to look at this. And here is also an option. Submit your query. Supposing you do not have an answer to a question, you can put your query. I think once that it is received, then the answer will also be created for that particular item which is there. So friends, as far as the report is concerned, the report has to be made in 10 days time. But most of the people come to me and say, sir, the 10 days is grossly insufficient. I do not deny that. In many cases, we have found that RPs have taken more than 10 days. The courts, adjudicating authorities are completely liberal. But the only thing which you need to do is, supposing you file on the 15th day, you file it on the 12th day. Of course, don't delay too much. But once you delay for 3, 4, 5, 6, 7 days, delay is there. File a condonation delay application. And I think the courts are very, very liberal in granting that condonation of delay. But please do that. File that application. This is extremely, extremely important. So report of RP is the basis, my dear friends. So I think I've given about the format. I've also mentioned about the limitation point. That is also very, very important. And this is the basis on which the reports, the application may be admitted or may not be admitted. Now, coming to a very important aspect, that is the limitation. Now, there are a lot of questions which are coming on limitation. A, whether the limitation applies, the answer is yes. How to calculate? What is the confusion? The default of the CD, can it be taken as a default by the personal guarantor? Number one. Number two, supposing the company has given an acknowledgement of debt in the form of, say, OTS, does it extend limitation for the personal guarantor case also? There are a lot of questions which are in the mind of the people. And friends, one more thing which I want to mention here is I think there is a very large attendance today. And I can see a lot of my friends and a lot of our IPNet members also. But I can see many of them who are not IPNet members. In IPNet, my dear friends, the membership is absolutely free. You can join if you are an IP. So just go to theipnet.com. I think you can look into the membership and you can press, and it is free. No, we are not charging any single penny from anyone. You get your individual dashboard. Now, what is the benefit? Let me tell you that. In IPNet, I think the entire group, it's not only one person, it is a group of so many people. We have got 4 regional heads, regional committees, and they are working very hard. And that is why you are seeing that every week we are holding one webinar, which is not easy to hold. But with the teamwork, with the effort of everyone who is present here, I think we have been doing it. All regions have taken up responsibility to hold every week, per week. So in 1 month, we have got 4 webinars. Now, once you do go there on the IPNet, you can join study groups. We have created 9 study groups. And one of the study groups is on personal insolvency, which I am heading, right? And Rashmi ji is very, very particular. She is always after me, and we always hold one meeting. We're very regular in holding. We hold one meeting in a month. This time we could not hold because of some reason. So we said, all right, let us convert into a full-fledged seminar. So we have created it as this webinar today instead of a study group. So that study group, my dear friends, will actually, we discuss online on one-to-one basis. Supposing like Mr. Hari Prasad also attends that. Supposing he asks a question, we answer it. Supposing I'm not able to answer it, then he may answer it or somebody else may answer it. So it's a like more of a discussion forum rather than it's on a seminar form. So everyone gets their answer. So there also we discussed about limitations. So let me share that. That is very important. How to calculate limitation, my dear friends. The date of default by the corporate debtor is not the date of default for the personal guarantor. The date of default of the personal guarantor is the date of invocation and non-payment. So let's do it on a step-by-step basis. Supposing X has given a personal guarantee and that guarantee is invoked on, say, 1st January 2025. And the demand is made by the bank after invocation that you pay immediately. Supposing there is an immediate payment, no further time. That means on 1st January itself, the person has to pay. So therefore, now the limitation to file an application under 95 will start from 1st January 2025, and you can add 3 years that time period. So typically it is 3 years from the date of invocation. Let me also explain why I'm saying invocation. What is relevant, my dear friends, in IBC? All of us know what is the trigger point. The trigger point is default. How will you calculate default? Default means there is a demand, it is unpaid, right? Isn't it? There is a debt which is due and payable and unpaid. This is the definition of default under IBC. So how will you create a demand? How will you create a default? First, you have to demand that money, and demand is nothing but invocation. So invocation plus demand becomes a demand. The amount becomes due and payable. And supposing the person is not able to pay, therefore there is a default. So it's a very simple formula to calculate, but there can be a small twist into this, which is like this. Supposing bank invokes the guarantee on 1st January and bank says that pay within 10 days. So then the time period, then the default will occur on the 10th day, not on the 1st of January, right? I think that's very simple. So it will start from 11th of or 10th of January. So 10th of January plus 3 years will become. But there is, again, you have to take it with a pinch of salt. So I think we have understood the basic concept. Invocation becomes the default either on the same day or whatever the as per the deed of guarantee. Supposing in the deed of guarantee, the person is supposed to pay within 7 days or 10 days, then the time limit time will start running from the last day of the 7th or the 10th day. And 3 years have to be calculated as per Article 137 of the limitation law, right? So I think we are all clear on this. But friends, is the date of default by the corporate debtor relevant or not? That is the big question. And I think there is a jurisprudence on this which clearly tells us that even the date of default by the corporate debtor is also relevant. How it is relevant? Let me give you a small example. Supposing the date of default by the corporate debtor is on 1st January 2021. forget about it is a COVID period or not. I'm not going into that detail. Let's simply assume that 1st January 2021 is the date of default and there was no COVID period, right? Let's assume that. Because if we bring in COVID period, then of course those periods have to be excluded. So 1st January 2021 is the date of default by the corporate debtor, right? Now, moving from there, 3 years will expire when, my dear friends? 1st January 2024. So if any financial creditor wants to start the proceedings against the corporate debtor CIRP, now they must file prior to 1st January 2024. I'm ignoring COVID period for this moment, right? So 3 years period. Now, guarantee which is given by any personal guarantor, most of the guarantees will absolutely tell you that they are continuous guarantees. There will always be a clause that this will be a continuing guarantee. Right? It cannot be revoked. And definitely personal guarantor cannot revoke it. So therefore, if it's a continuing guarantee, now supposing we are in 2027, supposing the bank invokes guarantee in 2027, is it a valid invocation? Supposing now, let's take one more case. Let's go back. Supposing the date of default by the corporate debtor is 1st January 2020. Oh, no, sorry, not 2020. Even let's go back maybe 10 more years, say 1st January 2000. Okay, so date of default by the corporate debtor is 1st January 2000. Now bank, and there is a continuing guarantee given by the personal guarantor. Bank rises from a deep slumber and say, I would like to invoke this guarantee on 1st January 2025. After 25 years, they say it is a continuing guarantee, it is a valid guarantee, and my period after invocation will start for 3 years. That means I can file the application up to 1st January 2028 if I invoke it on this. Is it a valid thing? Well, it doesn't look to be a valid, isn't it? Right? So there is a Supreme Court judgment on this. And I think that's a judgment which I'm going to share with you. Now, let's look at the Supreme Court says the fundamental principle of the Supreme Court is this, and I think all bankers, all IPs, all RPs must note this. This is extremely crucial and it will answer your questions about limitation once and for all. The Supreme Court says that the personal guarantee must be invoked when the debt is live. I'm just stating one sentence. If the debt has become time barred and the guarantee is invoked when the original debt has become time barred against the corporate debtor, then it is not a valid invocation. Are you getting my point? Let us look at the example now. Well, let's combine both the example. Default occurs on 1st January 2000. What is the limitation period to file any case? 1st January 2003, 3 years time period. So if the bank does not file any case and does not invoke that guarantee within that period of 3 years, can they invoke on 1st January 2004? Supreme Court says no. But assuming on 1st January 2002, the corporate debtor gives an acknowledgement of debt. Date of default is 1st January 2000. Debtor gives an acknowledgement of debt on 1st January 2002. So now the time period has been extended because it has been given before the limitation period has expired. So therefore, it starts from 2002 and it goes up to 2005. So now up to 2005, the guarantee can be invoked. Still, that is considered as a live period. If the bank invokes the guarantee on 1st January 2006, it is not a valid invocation. This is what Supreme Court says. So friends, let's remember. So what's one important line which is you must take care is that the guarantee must be invoked when the debt is a live debt. Live debt can be for the original period, can be through acknowledgement of debt. The extension of the live debt can be extended because of the acknowledgements, right? You can give an acknowledgement or whatever way it may be there. But if there is no acknowledgement and there is no extension and the time period has become time barred, then my dear friends, the invocation cannot be done. Now you must be asking that what is the judgment? So let me share that judgment with you, my dear friends, and you must note it down because this is an extremely important judgment for all of us. Okay, so let me share. You see that judgment with you. Okay, so this is the judgment. If you want to note down, friends, you can note down or you can take a screenshot if you wish to. Now, the judgment is 2006, 11 Supreme Court cases 506, Syndicate Bank versus Channa Veerappa Belleri and others. Right? So it is a judgment which was decided on 10th April 2006. Syndicate Bank, maybe one of my friends, and I can request our IPNet team, Brinda ji or Rashmi ji, they can write down the name of the case in the chat box if they are able to do that. So this is important, friends, right? Syndicate Bank versus Channa Veerappa Belleri and others, 2006 Supreme Court. Friends, may I request everyone to just please mute themselves because there are a lot of background noises are coming. Yeah, thank you. Okay. So now let us look at what is Supreme Court says in this judgment. And exactly the issues were similar, what we are talking about. And Supreme Court has given a fantastic judgment in this. Okay. Now, let us look at. Right. So let us look at, I think the judgment is not, I mean, there is small, in reading it is there, but let me see what we can do. Okay. Yeah. Para 14 is very important. Friends, para 14 and 15, I'm going to read. We have to enter a caveat here. When the demand is made by the creditor on the guarantor under a guarantee which requires a demand as a condition precedent for liability of the guarantor, such demand should be for the payment of a sum which is legally due and legally recoverable from the principal debtor. Very important word. So so first you need to do is you have to go to the deed of guarantee agreement. You will have to read whether, and most of the guarantee agreements have the similar kind of clauses that a demand must be made upon the personal guarantor, and demand must be made in a particular manner, right? By sending a speed post or registered post letter. So that must also be complied with. As an RP, my dear friend, you will also have to see whether the bank has invoked the guarantee in the manner prescribed in the deed of guarantee or not. This is also your task. So here, I'll just repeat once again. When the demand is made by the creditor on the guarantor under a guarantee, which requires a demand as a condition precedent for the liability of the guarantor, such demand should be for payment of a sum which is legally due and recoverable from the principal debtor. Underline the word legally due and recoverable from the principal debtor. Principal debtor here is the corporate debtor. If the debt had already become time barred against the principal debtor, the question of creditor demanding payment thereafter for the first time against the guarantor would not arise. Look at what the Supreme Court says. When the demand is made against the guarantor, if the claim is a live claim, that is a claim which is not barred against the principal debtor, limitation in respect of guarantor will run from the date of such demand and refusal or non-compliance. Where guarantor becomes liable in pursuance of demand validly made in time, the creditor can sue the guarantor within 3 years, even if the claim against the principal debtor gets subsequently time barred. I'll just give you an example. In fact, the Supreme Court has also given an example. The point what it is saying is, before I read further, let me share, tell you what exactly the last sentence means. The Supreme Court says that 1st January 2021, assuming the corporate debtor commits a default. So you have to now file up to 1st January 2024. Supposing the guarantee is invoked on, say, 1st January 2023, within the limitation period, 21 to 24. So 1st January 2023. Now, what is the time limit for filing the case against the personal guarantor? It will start from 1st January 23. It goes up to 26. Supposing they come in 2025, by that time, 26, by that time, the debt of the principal debtor has become time barred. Supreme Court says it doesn't make a difference. What is important is when the guarantee was invoked, whether the debt was live or not. That is the only question which I have to see. Subsequently, the corporate debtor debt becomes time barred, but your guarantee has been invoked before that. The time period of 3 years will start from the date of invocation and may be extended to a little further. I hope I'm clear. So now let us read what the Supreme Court says in the example which they have given. They have clarified it. Now let us say that a creditor makes some advances to a borrower between 10th April 1991 and 1st June 1991, and the repayment thereof is guaranteed by the guarantor undertaking to pay on demand by the creditor under a continuing guarantee dated 1st April 1991. Let us further say a demand is made by the creditor against the guarantor for payment on 1st March 1993. Though the limitation against the principal debtor may expire on 1st June 1994, because it will be 3 years from 1st June 1991. As the demand was made on 1st March 1993, when the claim was live against the principal debtor, the limitation against the guarantor would be 3 years from 1st March 1993. On the other hand, if the creditor does not make a demand at all against the guarantor till 1st June 1994, when the claims against the principal debtor get time barred, any demand against the guarantor made after, say, on 15/9/94 would not be a valid and enforceable. So friends, this is the judgment of a Supreme Court, which is still continuing. It has not been reviewed, or larger bench has not given any other, contrary decision to it. So this is a valid judgment as far as limitation is concerned. I hope I'm clear on this. If there are any questions, friends, I think we can answer that. We covered this in our study group, but we thought when we are holding this particular webinar.
Sir, there is a question in the chat box.
Yeah.
Yeah, Mr. Yatin is writing, in case CIP of CD is admitted and ongoing for 4 years, would this mean that the debt is live during the CIP period, which means guarantee can be invoked in the 4th year as well?
Yatinji, answer is very, very simple. Pendency of CIRP, pendency of DRT proceedings, pendency of SurveyC proceedings will not extend a limitation. It is the date of default of the corporate debtor first you will have to see. Now you will have to see whether the guarantee was invoked within the life period, that is 3 years from the date of the default. And if it has been done, then the limitation of 3 years for personal insolvency will start from that date. But pendency of CIRP will not extend a limitation. Acknowledgement of debt can, yes, acknowledgement of debt by RP can then can be done. So that can be done, right? That is possible. Okay. Yes.
Sir, it will be for the CIP and the liquidation period both, no?
No. No, typically, you see, it will be for CIRP only, because
Mr. Anil Kumar is writing, it means if CIP or liquidation is going on, then the debt is live.
No. I am not saying that. If CIRP or liquidation is going on, debt is not live, sir. This is what I answered for Mr. Yatin Sharma. Debt becomes dead once the period starts from the date of default of the CD. So you just concentrate on the date of default of the CD. That's all. Calculate 3 years from the date of default by the CD. The guarantee must be invoked during this period. Pendency of CIRP or liquidation does not matter.
Sir, date of declaration
Yes.
of NPA by the bank, is
Sir,
it amount to?
Yatanji, I think we have discussed this number of times, but anyway, your question is very valid. NPA, my dear friends, people are slightly confused about the NPAs. Let me share with you. When does our debt become NPA, Mr. Yatin? Tell me, sir. We're not able to hear you. Are you muted or unmuted? Okay. Anyhow, so the NPA is 90 days.
Sir, may I make one small issue, sir?
So the debt, when the debt has become, when the default has occurred at the first stage. NPA becomes after 90 days. So therefore, NPA has no relevance. Whether bank declares it to be NPA or not, as per RBI guidelines, that is their issue. The only point which we have to see is that the default should occur more than the threshold limit on that particular day, right? If it has become, then the bank must invoke that guarantee within a period of 3 years from the date of default. If they invoke after 3 years, it is not a valid invocation unless there is an acknowledgement of debt. That is what I'm saying. I hope I'm clear on this. Any confusion? I think we can take those questions.
Sir, during the CRP period or liquidation period, the balance sheets always shows that liability. So that is a continuous to be acknowledgement of debt, sir.
I'll deal with this, Mr. Ravi Shankar. I'll deal with it in a different manner. Number one, yes, Supreme Court says that acknowledgement of debt in the balance sheet is considered as acknowledgement of debt for the purpose of Section 18, but it is with a pinch of salt. You remember that latest judgment of the Supreme Court, what it says? It must be unqualified. Supposing in the balance sheet, naturally, as per the balance sheet, because it is appearing in the books of account, the corporate debtor has to show as a loan, right? So naturally, it will appear in the balance sheet. But in the notes to accounts, if the board of directors dispute it, or in their board of directors report they dispute it, then it is an unqualified, then it is a qualified acceptance. Then the Supreme Court says it will not tantamount to acknowledgement of it. So first thing, we'll have to take care of that. Two, assuming that is the case, if it is appearing in the balance sheet, so then naturally it is an acknowledgement of that, then it extends the period of limitation. But sometimes in these companies, balance sheet is not there for last 5 years. So therefore the personal guarantor can take advantage of that fact. Okay. Okay. Yes.
Sir, there is one more question, that can the order of DRT in OA will extend the limitation period?
No, it will not. But only thing is, Supreme Court has said one more thing, which as far as limitation extension, I think we'll have to go back to the Supreme Court judgments. I may not agree with that honorable Supreme Court judgment, but be that as it may, all of us have to follow that judgment, right? What the Supreme Court says. Supreme Court says pendency of the DRT proceeding or issue of notice by the DRT will not extend time limitation. But in one of the judgments, they have mentioned, I'm sure this will go to a higher bench sometimes. They say that if a decree is passed by the DRT, and for a recovery certificate, RC is issued by the DRT, it will start the limitation once again.
Yeah. So that was my question.
That is what the Supreme Court has said. So whether it is
that means once decree is received, right, and I issue a notice to guarantor that you make payment and he defaults in making payment, so I can file application against that guarantor.
See, in guarantor's case, it is slightly typical. We'll have to go to the exact facts of the case, because supposing you have already invoked the guarantee against the guarantor, then decree does not matter, because what is required is invocation of the guarantee. So if your time limitation has already expired, but supposing you have not invoked the guarantee, assuming now the decree comes and you are invoking for the first time after the decree, then you are right.
Sir, one more doubt, sir. Issuing of 13(2) notice against the personal guarantors, whether it will be treated as a demand notice?
Sir, 13(2). What? Can you repeat your question, sir?
Issue of
about 13(2)
notice
to
the guarantor.
Okay, let me, Mr. Subbarao, I have understood. Let me deal with you see, again, let me break it down. There are 2-3 aspects. One is whether Section 13(2) notice under SimplEase can be treated as invocation. The answer is no. There are a number of judgments by NCLAT which have clearly held that 13(2) notice cannot be treated as invocation. That is one. And two, please remember this. There are other judgments also where they say the guarantees or the bank guarantees or personal guarantees must be invoked in accordance with the deed of guarantee. So simply 13(2) will not satisfy. There is always a clause that the bank will invoke the guarantee in this manner. They will make a demand and the demand must be sent by registered post. So if it is not done in that manner, then probably it is not treated as invocation. So in any case, NCLAT has given judgments where they have clearly said 13(2) notice cannot be treated as invocation. Now there are other questions which are coming, and I must share it with you. If you are in a position to attend, please attend NCLAT hearing on 18th of February. There is an important question coming in my case only, and a very limited question. The guarantee was not invoked, was not at all invoked, because as per the deed of guarantee, so we said there is no invocation. Allahabad bench agreed with our contention and they dismissed the application of State Bank of India. Now State Bank of India has filed an appeal which is pending before the NCLAT now. Now what is the limited issue? They have now coming before the NCLAT, now they have taken a stand that I have issued form number B, which is the demand notice under IBC. You have to send a demand notice, right? So they say this demand notice can be treated as invocation. So when this appeal came up for the first time just 2 weeks ago, then the honorable chairperson, then he asked me, he says, Mr. Vakija, we are not issuing notices, but we are only deciding on one legal issue, whether Form B can be treated as invocation of guarantee or not. You just make your submissions on that. So now we have submitted our submissions, written submissions. Argument will take place on 18th of February. If you are able to attend, please attend that matter. I think virtually you can also hear. I think that's an interesting judgment. That will be a landmark judgment, right?
Is it Allahabad NCLT, sir?
And Allahabad NCLT, yes.
Yeah.
Allahabad NCLT gave it in our favor, 38-page judgment. But now that has been appealed, and only on one issue, the notice, not even notice has been issued. They say we'll decide it, we'll dispose it off on the next date. So that is the issue.
Sir, can you please share the case number if possible? We will get the order of Allahabad bench.
I will share the judgment with you, but for our benefit of our members, it is Deepak Kumar Singhania, State Bank of India versus Deepak Kumar Singhania.
Sir, in most of the cases,
these are the promoters of LML Limited, Singhanias. Okay, I'm defending them. Okay.
Sir, in most of the cases, after getting the decree of DRT, most of the banks are issuing only Form B. Even I have come across.
That is also not correct, but only thing is they have to invoke the guarantee as per the deed of guarantee. If they have not already done it, then the time limit has expired. If they have not, not done it, then they have to do it now. That is what you have to do. So everything depends on the facts of the case. But anyhow, I think the limitation point is clear, right? Okay.
No, sir, can I say one thing, sir? I have one short question.
Yes, sir.
Yeah. So I just wanted to know, you said the starting of CIRP or liquidation does not exclude the limitation. When the limitation is not, we have to see whether the guarantee is invoked or the date is live, and starting of CIRP does not make the date live.
Correct.
But sir, just for the understanding purpose, once the CIRP starts, the moratorium starts. Isn't it that date stands there?
No, because moratorium is not against the personal guarantor. No, that is clear. See, on the one hand, we are saying moratorium does not apply to the personal guarantor. Then why we are applying that moratorium against them?
Date of the principal borrower should be live.
That should be live. That's all.
So the CIRP starts, the moratorium starts. Does not it become live or no?
No. That doesn't remain live because the point is the limitation has to be seen in the context of the personal guarantor now. So that is to be seen. So once you have invoked, if you have invoked, that is fine. If you have not invoked, see, in any case, please tell me whether you have demanded the money or not from the corporate debtor. You have already demanded it. So when you have demanded it, your time period starts for DRT, for SurfaceC, for IBC. So you have to file within that time limitation period. So once that is done, then how can now CIRP extend? Now you have already started a litigation. So therefore it will not extend. Okay, whether moratorium or no moratorium is simple, that you cannot recover during this period. That is only a small this thing, because the resolution will become unsuccessful. But that does not will extend the limitation.
Okay. Sir, one clarification. May I, sir?
Yes, sir.
Sir, myself, Rajan Agarwal. Sir, so the basic thing what I want to understand is that, like, the debt suppose is payable on 15th February 2025. So the limitation period will start from day after tomorrow. It has got nothing to do with the calculation of 90 days for NPA purposes. The limitation purpose will start from tomorrow, sir.
Correct.
And one more thing, sir. In the example which sir you showed on the screen of Supreme Court, if you could take that again on the screen, sir. What has happened is lastly when the Supreme Court calculates the 3 years after which invocation cannot be done, it is giving sir more time than three years.
No. See, I'll tell you. Look at this.
So 15/9/1994. Point C.
Let's go one by one, right? Creditor makes some advances to a borrower between 10/4/91 and 1/6/91.
Yes, sir.
And the repayment thereof is guaranteed by the guarantor undertaking to pay a demand under a continuing guarantee dated 1st April 1991. Clear?
Yes, sir. Yes.
Let us further say that a demand is made by the creditor against the guarantor for payment on 1st March 1993. That means
yes,
within a period of 3 years.
Yes, sir.
Now, though the limitation against the principal debtor may expire on 1/6/1994.
Yes.
The demand was made on 1st March 1993 when the claim was live. So it was a live claim?
Yes.
So now the demand was made on 1st March 1993?
Yes.
Now the limitation for the guarantor will start from 1st March 1993 and it will go up to 1st March 1996.
Okay. If the creditor does not make a demand. Okay. So, but then, sir, in the C point, there is a mention of date 15/9/94 because
No. Please read it with a pinch of salt. They are saying example. Let's read it. On the other hand, if the creditor does not make a demand at all against the guarantor till 1/6/1994, because now the debt becomes time barred against the principal debtor.
Yes, sir.
When the debt claim against the principal debtor gets time barred, any demand against the guarantor made thereafter say means they are giving an example only.
Oh, okay.
Say on 15/9.
Yes.
Then it will not be a valid or
yes, sir. I didn't see that word say on. I got it. After the date.
No worries. Okay. So
sir, I have a question, sir.
Yes, sir.
Acknowledgement of date is say 31st August 2019.
Acknowledgement of date is 31st August 2019. Okay.
Yeah, this is the date of signing of the balance sheet.
Okay.
CIRP commences 1st January 2021. Liquidation 1st January 2022.
Okay.
Dissolution 1st January 2023.
Okay.
Now, if the decree is obtained by the financial creditor on 1st June 2022.
Right.
He has the limitation of 3 years for invoking the guarantee. But CIRP or liquidation is not there in the NCLT. Can invocation be done or application against personal guarantor be filed if CIRP is not pending?
See, the point is, filing of an application against a personal guarantor is not dependent upon pendency of the application. Pendency of CIRP or liquidation. So let's assume, supposing a bank invokes a personal guarantee against a personal guarantor, does not go for CIRP. Can he invoke the section 95 against the personal guarantor? The answer is yes. So it is an option, sir. It is not dependent upon CIRP or liquidation. These are two different activities. They want to proceed against corporate debtor, let them proceed. If they don't want to take any action against the corporate debtor, that is their problem. But if they want to proceed only against a personal guarantor, which is allowed as per the Indian Contract Act, because the liability is joint and several.
So it's okay, but whether undergoing corporate insolvency dissolution process is a must or no?
No, sir. No, sir. Why do you say that? Why do you say
because
that?
Because in one of my case in NCLT, Calcutta, admission was not made since.
No. I'll tell you, sir. I'll tell you. What you are talking has been overturned by NCLAT now, right? That judgment which you are referring to, there is not only one judgment. There are two judgments of Calcutta bench. In Kolkata bench, they have said, and which I agree with that judgment. There is a judgment which has been overturned by NCLAT, which I don't agree. Respectfully, with due respect to NCLAT, I do not agree with that judgment. Let me clarify to the people. I think We will talk about that, but any other question on limitation first? We'll come to that portion, whether CRP is pending, whether you can start personal guarantee or not. We'll talk about that.
Sir,
Any question on limitation first?
sir, may I ask the question?
Yes, yes.
Yes, sir. Sir, so you have said that if date of default for CD does matter for a date of default for personal guarantor. Suppose I have issued, I'm the creditor, I have issued form 3 to CD, and they have not paid within that 10 days. So date of default is the issue of form 3 to the CD. So date of
Just we are talking about personal guarantee. Form 3 is for operational creditors.
form 3
गारंटी कहाँ आएगी? Where the guarantee will come?
डेट ऑफ डिमांड जो भी है, डिमांड नोटिस मैंने सर्व किया सीडी को फर्स्ट.
60 demand notice is served only in operational creditor case. It is not done in financial creditor.
Okay. So what will be the date of
default? Then the question of personal guarantee will not arise. Na? Personal guarantee is typically, if you ask me, a personal guarantee is always related to a financial debt. It is not. It can be, but it is never related to operational debt, according to me. कोई बैंक लोन देता है तभी तो गारंटी देते हो ना. ऑपरेशनल डेट. If it is a financial creditor, you don't have to send the demand notice.
Okay. So next question is date of default for financial creditor. Suppose 1st January 2022.
Sorry, what is it?
1st January 2022. Date of default for CD is 1st January 2022. So we for case of this PG, we have 3 years from the 1st January 2022 for invocation of that personal guarantee. And then after 3 years from the date of invocation of personal guarantee, we can file that application under section 95 or 94 from 3 years from the date of invocation of personal guarantee.
Absolutely correct.
So we have 6 years subject.
Don't have. You can say almost 6 years. I mean, you can invoke on the last date.
Right.
To that extent, you can say 6 years. Yes.
Okay. Okay. Thanks.
But don't count it from the date of the default by the CDC. The point is, for filing the application, you still get 3 years, but from the date of invocation. But invocation must be when the debt is live.
Yes.
So date of default by the CD is relevant only for invocation first. For the live debt or time bar debt. But that's all. So
okay, thanks.
Okay.
Sir, I have one small doubt, sir.
Yes, sir. Go ahead, sir. All small and large doubts. I think, friends, just hang on. Friends, anyone who wants to contribute, so please contribute. If I'm saying something wrong, please also correct me if I'm wrong. Mr. Hari Prasad, please.
Yes, sir. This is converted to that question only, sir.
Okay. Yes. Okay. Yes, Mr. Vaidya. Go ahead, sir.
Date of invocation is 1/1/2021.
Sorry?
Date of invocation is 1/1/2021.
Okay.
So you told the limitation period ends on 1/1/2024.
Correct.
My doubt is whether it is 1/1/2024 or 31/12/2023. Which one is correct?
Sir, I just took a small example. You have to calculate 3 years, and for calculating 3 years, the date of invocation has to be excluded.
So it will be around 31/12/2023 only. Am I right, sir?
No. See, I'll tell you because you will have to exclude 1st January.
Date of execution of document, you have to exclude, sir. Date of execution of document, you have to exclude.
No. Even date of invocation has to be excluded as per General Clauses Act.
Yes, correct.
Sir, another question is, suppose when we are issuing SARFAESI notice, we are issuing SARFAESI notice to all the borrowers and guarantors.
Okay.
So the SARFAESI notice is very clearly mentioning that you have to remit the entire outstanding amount within 60 days from the date of receipt of this notice. Can we treat it as an invocation of notice against the guarantors?
No, sir. No, sir. Because there is an NCLAT judgment very clearly. I'll share that judgment with you. These NCLAT has considered this. They say the purpose of 13.2 is entirely different. It is not invocation. Invocation must be in accordance with the deed of guarantee. Unless in that 13.2 notice you modify that and say this may also be treated as invocation of guarantee as per deed of guarantee because then it's a different matter altogether. But if you don't write that specific word, then simple notice under 13.2 and NCLAT says it cannot be treated as invocation. Okay.
Okay, sir. Okay.
Right.
So
Yeah, go ahead, sir. Go ahead. Right,
May I ask, sir?
Yeah, please go ahead. You have been
Okay.
patient. I think please go ahead.
Yeah. No, sir, sorry, again, coming back to the limitation point again. Sir,
Right.
in a CIRP, the debt is admitted. It is also admitted by the RP, right? So it is not where it is not admitted.
Correct.
Now, when the debt is already admitted and is part of whatever is to be payable, why are we saying that it is not live? Because see, the point I'm just trying to, which I'm not quite able to understand, is you've said that once the CRP starts, you just look at the 3-year period from now. When I say the debt of the financial creditor has already been admitted and this has to be paid, of course, as per the resolution plan and all, why would the debt not be live during that period?
No, sir, that is not treated because see, the point is, what is the date of limitation? Limitation is for the start of the proceeding. The relevancy goes after that. The moment you have started the litigation, like under Section 7, you have already started, so you have already consumed that limitation period. Now where is the question of limitation being extended? The filing of the claim is a procedural matter. RP will definitely admit it because he says, all right, it is appearing in the books of account. So that is what it is there. So admission and under CIRP, which is a procedural part of it, will not extend limitation. On limitation ka question, Yatinji, let us understand. You have exhausted that limitation point and you have already started the CIRP.
Right.
Can you use that
No,
again?
but I'm
bullet.
sorry.
1 minute. Just let me. Can you use one bullet again? You have already fired a bullet. You have started litigation. So limitation का question तो खत्म हो गया ना? Where is the question now?
No, but I'm looking at
You
correct.
have already consumed the bullet of limitation. You cannot use that again now. Where is the question of using that again?
No, so of course, with a CIRP, I'm not saying that the limitation is extended. We are of course talking relating it back to the personal guarantee invocation, because I understand your point saying that okay, fine, if it has started, then there's no question of any limitation extending. The debt is not live, even if the debt has been admitted and there's no dispute around the admission. So from what you're saying is then in any case, after CIRP is admitted, 3 year is the limitation for PG in all cases. There
Correct.
cannot be any other situation, because what I wasn't able to comprehend is, I understand that you're not taking multiple limitation vis-a-vis the CRP. Here, what we're looking at as the limitation vis-a-vis the personal guarantor. Now, if the RP has admitted my debt and there's no question of limitation there, the company acknowledges I have a debt is due, then why should not the debt be considered live when I'm looking at from a personal guarantee point of view? I've got your point if that's the position. So
I'll tell you why. As far as this RP is concerned, you may call it as an admission, but you see, the point is there is a claim which has come, which he says, all right, because then for the purpose of the resolution plan which is coming. But there is no, in fact, there is no admission by the corporate debtor itself. Today, the management is gone. Now, RP may do any damn thing. That does not mean that it will extend limitation. So therefore, you may say the same CD is continuing. That logic may work for you. But at the end of the day, let's understand. You have already invoked that limitation ground. You have already come here. The limitation matter ends. Now the limitation has already started, and Supreme Court says, and let us not forget it. What is the trigger point? The date of default, and that is sacrosanct. That cannot never change unless there is an acknowledgement of debt. Now, what you are saying is, my claim is admitted, that should be treated as acknowledgement of debt. I'm sorry, it cannot be treated under Section 18.
Suppose during CIRP, if we continue obtaining acknowledgement of debt from the creditors, if they obtain continuing acknowledgement of debt, it extends.
During CIRP, who is going to give you?
Financial creditor will obtain the acknowledgement from the debtor.
From whom? Debtor means?
Corporate debtor.
The corporate debtor is already in the CIRP. Who is going to
already in CIRP.
Who is going to give you? RP.
So the RP, because the debt claim is anyway part of the records. I mean,
no, sir. That is not correct, because you see, let us understand. Let us look at Section 18. Section 18 has got 3 conditions. Number 1, the acknowledgement of debt must be signed by the borrower, right? Signed by the borrower. It must be signed before the expiry of limitation. And you see that these are two very, very important conditions. So signed by the borrower means what? RP giving, you see, he has no authority to admit, or I mean to give that kind of a this, because CD generally gives an acknowledgement after you see the board resolution and other things are passed. So I think this will create a whole lot of confusion. So taking acknowledgements after, and no RP is going to give you. I'm telling you, no RP will give you an acknowledgement of debt. And therefore, there is no question of any acknowledgement of debt. You are simply filing a claim which is admitting as per the procedural part. That's all.
Sir, basically, we
That's
want
all.
to say, sir, that balance sheet is prepared by RP. Now, balance sheet is acknowledgement of debt.
No, but that, see, the point is, all I'm coming back again. You have already exhausted limitation. Where is the question of fresh limitation in this matter now? The limitation once exhausted, then it
One more thing,
cannot be revived like this.
sir, one more thing is RP is not admitting or anything, sir, just collating is not admission. No, so the word collating may create a problem then.
Correct. That is also one of the important things, because Supreme Court says it is only a collation, it is not an admission. It is not adjudication. So he is not adjudicated. So if we go back to the Supreme Court judgment, again, it is not adjudication. If it is not adjudication, how it is acknowledgement of debt then? So I think he is simply collecting. He is only a via media to collect the claims. That's all. That's all. And this is the process, legal process, which has curtailed this. Okay. Yes. Any question before I go to that other side? No more question?
Sir, from practical point of view,
That amount,
sir, from practical point of view, whether all these things are possible within 10 days, what you are saying, to examine the limitation, to get into these details and find the actual position.
I don't think, Mr. Vaidya, there is difficulty. Within 10 days, I think this is possible. No, not a problem. But anyway, I mentioned that supposing there is a delay of say 3, 4, 5, 6, 7 days, doesn't matter. You file your report later and you can file a condonation of delay application. I have seen condonation of delay application for even 1 month. So NCLTs are little liberal of that. Okay.
Both are on the same application or separate application? Condonation delay and
Typically, it should be on separate applications. It should not be a part of the, you can say, the report, because in report you are simply saying recommending, right? So don't burden that particular report. So you can file a separate application with a separate prayer for condonation of delay.
yeah, filing in both on the same, sir. That may be wrong.
I mean, it's not wrong, but then the bench may say, no, you should have filed it. So, I mean, why to get into that? Because most of the trend is the best practices file a separate application. Okay. Right. All right.
I have one view with regard to the admission of claim.
Yes, sir.
So when RP receives the claims,
Correct,
then two columns are prepared. One is claim received, other is the claim admitted.
Correct.
So the moment he is writing that these are the claims which I have admitted, will it not be treated as admission of claims?
Oh, sir. So let's understand. I think we are all getting into a very kind of a small, you see, ball kind of a thing. That, oh, this, see, please understand, RP is working as per the legal provision. He has got to receive the claims, and he has. So therefore, if that is the case, then all operational creditors' claims are also admitted. Their limitation will also not expire then. That's not the case. Default is the trigger point, sir. From the date of default, you have to calculate 3 years. And once you have started litigation, the matter ends. Why you have limitation? So limitation.
Sir, RP is expected to prepare the balance sheet and P&L during the CRP period. In the balance sheet, the amount is shown as continuing liability.
Sir, RP signing the balance sheet is something different. If the promoters are signing during CRP, then it is a different matter.
No, promoters, the promoters can also sign. RP is signing on behalf of the promoters. RP steps into the shoes of board of directors.
That is all right, sir. But that will, according to me,
the liability was continuing. The liability was continuing, and he is updating the books of accounts. So that is the acknowledgement.
Sir, let us understand why this application was filed. Please tell me. Because the debt was not paid, isn't it?
Sir.
So therefore, once the RP is preparing a balance sheet, now the promoters can always say, write down that we are disputing this debt. Well, then how can it be an acknowledgement?
But when they have not disputed in the previous balance sheet, they have signed. Sir, if the balance sheet signed by them is not disputing the amount.
So if they have signed it, then it's a different matter, sir. That will always depend upon the facts of the case. Now, see, today, signing of the balance sheet by the RP cannot be substituted as an acknowledgement of debt. Let's understand that. If the promoters are signing it without dispute, then it may be treated as acknowledgement of debt.
Yes. So my submission is, sir, that before the commencement of CRP, the balance sheet was signed by the promoters and directors, and it was not disputed. And thereafter RP is updating. And if RP is not updating, not preparing the balance sheet, he is violating the law. So one violation cannot lead to other immunity to the PG.
No. Now we are going into a different direction at all, sir. That it is not related to that. The only answer which we have to see is what is the date of default. The date of default has to be seen. 3 years have to be calculated. If during these 3 years period there is an acknowledgement of debt by the company, well, that is fine. Otherwise, there cannot be any acknowledgement of
this is.
RP.
I think this is something which needs to be clarified, because if I do not prepare a balance sheet, my debt does not become debt. I'm violating my law.
No.
I'm supposed to prepare the balance sheet.
So that is all right. So let him prepare the balance sheet. Who's denying it? In 90% of the cases, balance sheet is not being prepared because it doesn't have the data. So let's not discuss on that. If he has to prepare it, let him prepare it. Who is denying that? But that will not lead to acknowledgement of debt. I'm very clear in my mind. It will not lead to, because you have already started the litigation. It does not extend limitation. Okay. So let's go to the next point. Okay.
Can I ask one question?
Yeah. So the next question, which
in one of my cases, since assume the date of default was in 2010, and after 6 or 7 years, the OTS was given by the bank, which was I think it was failed. So whether the failed OTS will give a fresh lease of life to the limitation?
Sir, again, you have to see what was the date of default.
2010. In 2010.
When was the OTS given?
2016.
So how can it be there, sir? Acknowledgement of debt, read section 18. It must be, acknowledgement of debt must be before the time period of limitation expires.
Okay, sir.
It has to be given before 2013. So later on, if you start giving this thing, that doesn't matter, no? See, that is what I'm saying. Even in case of RPs also, supposing there is a balance sheet which he prepares, but already 3 years have already gone, that is not covered under section 18. It is not covered under section 18 because it is beyond the 3-year period. Acknowledgement of debt must also be within the period of limitation.
Sir, after the limitation period, suppose a borrower is approaching the bank and he is giving a OTS request.
Right.
And whether we can, limitation act we can ignore, and whether Indian Contract Act section 25A, whether we can take it and we can file it.
Yes, you can take advantage of that. You can take advantage because it becomes a fresh, but the point is there has to be an agreement and it should not be without prejudice, because typically in OTS they write without prejudice. So without prejudice means it is not a clear-cut acknowledgement. The point what you are saying is, like, I'll tell you, I'll explain to the other people also. Supposing the debt has become time barred. After 3 years, then the borrower says, okay, I'm willing to pay you. Right? Supposing he signs a contract or OTS. Now what happens is, whether the limitation extended, answer is no, but it is a fresh contract now. So on the fresh contract, naturally the fresh limitation will come into being now. So you can't file a case based on the previous litigation, but you can file the case on the next agreement. It is a fresh agreement. It's a fresh contract. So and this is what the Indian Contract Act says. That is why he's referring 25A. The reason what is mentioned there is whether it is a valid consideration, because debt has become time barred. And we know for a contract, there has to be a valid consideration, legal consideration. Consideration must be legal and valid. So whether a time barred debt can be treated as a legal and valid consideration or not, so the Indian Contract Act makes an exception. They say, okay, if somebody agrees to pay a time barred debt, it is a valid consideration. You get my point? So that is on a different context. So obviously, if he agrees, then it becomes a fresh agreement. Okay.
So from that date of his letter, another 3 years definitely we will get under Indian Contract Act.
Not a letter, sir. Agreement.
The agreement means he is ready to, and we are accepting it. So it will become an agreement. So he is giving an offer that I will remit the amount within 3 years. So the bank is accepting it. And
No, but if he's saying without prejudice, then it's a different issue. If it is admitting a clear-cut liability, yes, I owe you, I'm ready to pay, then it is a different matter, sir. And then it is not OTS, sir, please understand. You have to accept that OTS, then it becomes a contract. Then it
Yes.
becomes valid. So only simple OTS letter after the time barring will not help you. When you accept that, and if it becomes an agreement, only then you can take advantage of Indian contract.
Okay, sir. Thank you.
Okay. All right. I think we have dealt with a lot of questions here. Good. Okay.
Because limitation is the factor which is delaying the admission of the all PRP cases, sir.
Yeah. No, I understand.
So it's very important.
Right.
Because most of the PGs are disputing because of limitation only.
Naturally, they will you see, do that. But
that is very important you have dealt with, sir.
But
I still feel the balance sheet admission prepared by RP should be taken as a debt ally.
Sir, according to me, it is not. Let it go to Supreme Court. We'll see. I'm not bothered about NCLTs and NCLATs. Please understand that. I'll be
Yeah, but
then it goes to Supreme Court, and Supreme Court gives a final judgment on this. Because like now coming back to any other question? I think.
Sir, there is a question.
OTS proposals.
Yeah, Mr. Srinivas, you go first, and then ma'am, you
Sir,
can.
OTS proposal, how many times bank can give, sir?
A lot of bankers are there, sir. Jitne baar dena de do na, you can give any number of times.
They can change any number, sir.
They
need recovery.
If the party they have rejected and again they are giving proposal.
Sometimes what happens is they refuse again they submit. How can they stop that person in giving?
Will it extend the period of limitation, sir?
Sir, if it is you can say without any this thing qualification.
Yes.
If it is unqualified OTS that I'm admitting liability, then it is an acknowledgement of it. Okay. But he says, oh, I'm not admitting, but I'm still giving you a proposal. Then it's a different issue. Then it's a contested issue.
Better to take the fresh documentation. Party is coming for this agreement. You go for a fresh documentation.
Absolutely. You're absolutely right. You go for a fresh documentation and enter into a new agreement. That's all.
What are the outstanding as per the contract of the date? You execute the document.
Correct.
And it will extend the.
Correct.
You can give also. If you can give also. If you can say like that.
Evergreening the debt.
That is small submission, sir. It is not a question.
I think.
Very precise.
I think ma'am was in line, so let her give her a chance first.
Sir, there was a question in the chat box. Okay, you say.
Yeah, yes.
So, sir, my question is, in one of my case, a default occurred on in 2018, and guarantee was invoked. Guarantee was also invoked in 2018, and demand notice under IBC was issued in 2023. So now the limitation period shall be counted from invocation or demand notice, because the document which reflects the invocation of guarantee is actually not properly drafted. Only the subject written is invoking guarantee, but in the paras written is actually the bank is not invoking the guarantee. Only through subject we can decide that it is invocation document. So shall we count from invocation of guarantee or demand notice under IBC?
Okay, ma'am, number one, as far as demand notice is concerned, whether it can be treated as invocation, that is what I mentioned just now, that there is an issue which is to be decided by NCLAT on 8th of February, where I am appearing. Okay. So that landmark judgment may come. Okay. Now, having you see, the date of invocation is important. So in 2018, now it depends upon the facts of the case. I can't comment without looking at all the facts, but only one point you must consider. Substance is important than the form, more important than form. So just if they are written in the subject, but in the body of the letter they have not invoked it, then it cannot be treated invocation according to me. But don't go by my advice unless I see the papers. Okay. This is only prima facie what you have said. Okay.
Thank you, sir.
Don't blame me tomorrow if something goes wrong. Okay.
No. Thank you.
Yes, Rashmiji, I think we have to go to another important issue, and time is running out. So let's
already 6:53, 5:53.
Yeah. So I think we can cover that other issue, and
Yes,
then
sir,
we'll come.
please. Yes, sir.
The most important question, my dear friends, is pendency of the CIRP proceedings. Calcutta bench in 2 judgments clearly mentioned that if the CIRP against the corporate debtor or the liquidation against the CD is not pending, then a case of personal guarantor cannot be filed before the NCLT. NCLT has no authority to consider this. They have dismissed 2 applications. The matter was considered by Honorable NCLAT in a very, very recent judgment which has happened, my dear friends. Let me bring it on record. Let me see. And that is Anita Goel versus, okay, just let me see. Yeah, Anita Goel versus Vistra ITCL India Limited. So let me share it on the screen. Let's read that. Of course, all of us have to follow, including me. I will also follow that. But with due respect, I don't agree with this, right? So why I don't agree? Of course, I will mention that. So let us see this. This is the judgment which I'm showing, my dear friends. Anita Goel versus Vistra ITCL India Limited. And this judgment came up very recently. And the date of judgment, I believe, is, just give me. I think it came in January only. Okay. Yeah. So the date of judgment is 23rd January 2025. Okay. So let me show you the last operating paragraphs only, and I'll not go into the greater detail. Let's read the last 2 paragraphs which are relevant. Okay. Right. So now let us read this para 42 onwards. Learned counsel for the appellant has relied upon the judgment of NCLT Kolkata bench in Aditya Birla Finance Limited versus Sarita Mishra and Tata Capital Finance Services Limited versus Arjun Agarwal. Coming to the judgment of Aditya Birla Finance versus Sarita Mishra, the said proceeding was initiated by the financial creditor against personal guarantor under 95 subsection 1. The application came to be rejected by the NCLT Kolkata bench, holding that NCLT shall have jurisdiction only when the proceedings for insolvency resolution or liquidation is pending against the corporate debtor, and the application under section 95 by the FC was dismissed. It is relevant to notice that NCLT Kolkata bench had noticed the judgments of this tribunal in SBI versus Mahinder Kumar Jajodia, as well as Mahinder Kumar Agarwal versus PTC India Financial Services, but NCLT proceeded to distinguish the such judgment without there being any real distinction in the issue which has arisen for consideration. To the similar effect is another judgment of NCLT Kolkata bench in Tata Capital Financial Services versus Arjun Agarwal, decided on so-and-so date, on the same date on which judgment of Aditya Birla was delivered. In the said judgment also, the same view has been taken by NCLT Kolkata while dismissing 95. The above 2 judgments delivered by a Kolkata bench are in the teeth of binding judgments of SBI versus Jojodia and Mahinder Kumar Agarwal versus PTC. An artificial distinction which is sought to be drawn by NCLT Kolkata bench is illusory and without any basis. The NCLT Kolkata bench was clearly bound by the precedent declared by this tribunal, especially when the judgment of this tribunal in SBI versus Jajodia was affirmed by the Honorable Supreme Court by its order dated 6/5/2022 as noticed above. In view of the law laid down by this tribunal as State Bank of India versus Jajodia, where application filed by the FC without there being any pending proceeding against the CD was held to be fully maintainable, both the judgments of NCLT do not lay down the correct law and are per incuriam. The above judgments relied upon by the appellant cannot thus support the submissions advanced by the appellant, and NCLT has no jurisdiction to entertain 95 application by the FC. In view of the foregoing discussion, we are not proceeded to accept the submission of the appellant that NCLT Delhi has no jurisdiction to entertain Section 95 application filed by the FC against the personal guarantor for initiating insolvency process. We do not find any substance in any of the submissions raised by the appellant. There is no merit, hence both the appeals are dismissed. So this is the judgment of the Honorable NCLAT, which now clearly holds, based on its probably the earlier judgment, Mahinder Kumar Jajotia judgment, where they are clearly saying that despite the fact that there is CIRP is not pending, the liquidation is not pending against the CD, still the application against the personal guarantor can lie and can be filed in the NCLT. right? This is what the NCLAT says. So all of us are bound by it till the time it reaches the doorstep of Honorable Supreme Court. As far as Mahendra Jajodia judgment, which they have mentioned that it went to the Supreme Court and Supreme Court has upheld. Actually, Supreme Court has not upheld. In fact, the appeal which was filed in Supreme Court was dismissed. So typically, no merits were heard, but it was simply dismissed. Right? We are dismissing the appeal. There is no merit in this. That's all. That is only one word which has been dismissed. So Supreme Court did not consider in an elaborate manner. But be that as it may, I mean, NCLAT is right in treating that, okay, our review has been upheld because it has been dismissed by the Supreme Court. Appeal has been dismissed. Be that as it may, friends, with due respect, my view is a little different. But take it with a pinch of salt. We'll have to follow NCLAT till the time we get any Supreme Court judgment, right? This I'm saying. So I'm not saying that we do not have to follow. I'm saying very categorically that we have to follow NCLAT judgment, and all benches will follow that. But regardless of that, I'm saying, because I have a different opinion and I have a right to have a different opinion. The reason I'm saying why I'm saying is this, my dear friends. There are Section 60, which they have relied upon, probably has not been gone into detail by the NCLAT. Now, why I'm saying so? Because if you look at you see the sections particularly, they have ignored the impact of Section 60 subsection 2 and also 60 subsection 3. Now, let me share with you, there is an Honorable Supreme Court judgment already there. So let us look at, let me share the Supreme Court judgment now. Now, Supreme Court judgment in Dilip Jwarik, you see the earlier judgment of Lalit Jain, I think where it is. Okay, yeah. So Lalit Jain judgment. Lalit Jain, I think all of us know that they are on particular issue, right? This particular issue only, that the provisions of this IBC, particularly Section 60, were upheld, right? That was also upheld. Now, if you look at, let me show you that paragraph. Okay. Yeah, look at this. In para 99 of Lalit Kumar Jain judgment, which is a categorical landmark judgment in personal insolvency, what the Supreme Court says, and this particular thing has been ignored by Honorable NCLAT, with due respects. What does it say? The argument that the insolvency process, application of moratorium and other provisions are incongruous and so on in the opinion of the court are insubstantial. The insolvency process in relation to corporate persons a compendious term covering all juristic entities which was described in Section 2A to 2D is entirely different from those relating to individuals. The former is covered in provisions of Part 2 and later by Part 3. Now we are talking about the important thing. Section 179, which defines what the adjudicating authorities for individual is subject to Section 60. Now, friends, look at the next sentence which I have highlighted. Section 60, subsection 2 is without prejudice to Section 60, subsection 1, and notwithstanding anything contrary to the contained in the code, thus giving overriding effect to Section 60, subsection 2. This is an important statement, my dear friends. Section 60, subsection 2, if you read the opening sentence, it says, without prejudice to Section 60, subsection 1, and notwithstanding anything to the contrary contained in the code. The Supreme Court says Section 60, subsection 2 is overriding 60, subsection 1. 60, subsection 1 says that NCLT has got the jurisdiction. 60, subsection 2 says something else. 60, subsection 2 says that that if the CIRP is pending, only then an application can be filed in the same NCLT. And Supreme Court says 60, subsection 2 overrides 60, subsection 1. Now, if we apply this law, my dear friends, then where is the question? Now, look at this. 60, subsection 2, as far as it provides that application relating to insolvency resolution, liquidation or bankruptcy of personal guarantors of such corporate debtors shall be filed before NCLT where proceedings relating to corporate debtors are pending. 60, subsection 2 uses the word pending. And Supreme Court says this subsection overrides the previous subsection. Everyone is going by 60 subsection 1. No other jurisdiction is there. And remember one more thing. I think this argument probably was not taken before the Honorable NCLAT. Unfortunately, 60 subsection 3 talks about transfer of proceedings. Now, according to me, if 60 subsection 1 subsumes 62 and 63, what is the need of 63 then? 63 says, if the proceedings have been started in any court against a personal guarantor, the moment CIRP starts, those applications will get transferred to the same NCLT bench. Now, my dear friend, if the logic is that it can start only in NCLT, where is the question of transfer? So therefore, it is rendering 60 subsection 3 completely otiose. And Supreme Court says 60 subsection 2 overrides 60 subsection 1. I think this point has been completely missed by Honorable NCLAT. With due respect to them, I think if they would have considered this judgment, this is also a judgment of Supreme Court. So therefore, my dear friends, and two logics. Number one, 60 subsection 2 overrides 60 subsection 1. 2, 60 subsection 3, which talks about transfer. What is the need for transfer then? If everyone believes that personal guarantor, applications can only get started in the NCLT alone, where is the question of transfer? The transfer will happen only when the proceedings have started against the personal guarantor in some other court. So therefore, my dear friends, I think they have missed the bus. I hope that Anita Goel challenges it in the Supreme Court, and if it challenges it, probably we'll see a different result in this. Okay. So anyway, I think I wanted to present, but anyway, again, I'm saying we have to abide by NCLAT judgment, which is still rules the roost. That is the day. So therefore, I think we'll have to follow Anita Goel till the time it is overturned by the Honorable Supreme Court. But my view, as I showed you, it is completely different. All right. I think we had a fantastic discussion for a very long time. It is almost more than 6. We have jumped our time also. So friends, I'll just stop here. Any questions or anything, we can have a discussion, quick discussion. Otherwise, I will hand it over to Brinda or Rashmi ji. Yes.
Sir, we can invite all of them to join our personal study group for personal insolvency.
Absolutely. Friends, one more request. I had already made that request. If you are not an IPNet member, please become one. Go to theipnet.com. Just write THE, theipnet.com. You will find membership link. You will find join membership. Click that form. It is very simple form. Within 2 minutes, you will get your membership number and you will get a personal dashboard. Along with that, you can join study groups. And all of you can join our WhatsApp group, which is also doing fantastically well, and also study group, which any study group you want, right? CIRP, personal guarantor, liquidation, whatever your questions are there, your routine questions will be answered there. That is what it is doing wonderful. Thank you, Smiji, for reminding that. Thank you.
Excuse me, sir, from where we can get the link of WhatsApp group?
Madam, once you become a member of IPNet, you will get the first email of your welcome email. In that welcome email, you will get, because it is a restricted WhatsApp group, we are not circulating WhatsApp invitation otherwise. We are giving it only to the members.
And
So in your email, you get that link invitation. Just click that link, you will be admitted.
okay. Thank you, sir.
Sir, that group is only for IPs.
Yes, that group is unfortunately for IPs right now. Srishti, you have to pass that exam.
Sir, I have already passed, but I don't have the membership.
कोई बात नहीं, जब बन जाओगे तब आपको आपने अप्लाई तो कर दिया ना.
हाँ ये सर वो 50 आवर्स का एजुकेशनल कोर्स का टाइम ही नहीं आ रहा है.
REC pending है. Okay.
Sir, one general query with your kind permission. Sir, one general query with your kind permission.
Yes, sir. Go ahead.
Sir, if the guarantee is a continuing guarantee, which normally it is, all guarantees are continuing guarantees, then where is the question of limitation? The bank can file, invoke the guarantee when it wants.
Rajan ji, यही मैंने question पूछा था. Please understand. You gave a guarantee. You gave a guarantee in 1991. The debt was, the default was committed by the corporate debtor or any debtor for whom you gave the guarantee in 2000. Does it look logical that the bank can invoke in 2025 after 25 years? Limitation नहीं होना चाहिए. So continuing guarantee has also been interpreted by the Supreme Court in that judgment which I showed you. So they say continuing guarantee also has tenure, but the tenure is 3 years. It should be invoked within 3 years from the date of default by the principal debtor.
Coexistence.
Now the question is, sir.
Yes, sir.
The continuing guarantee means term loan may normally guarantee for 3 years. Continuing guarantee means that is there in the running account CC, cash credit and overdraft facilities. So that is only, that 3 years is not going to be changed.
No, that is not going to be changed, but there is a continuing guarantee if the principal debtor has not committed a default.
Yes.
If they have committed a default, then the continuing guarantee also put a break.
It is going to be crystallized on the date of default only.
Absolutely, sir.
Correct.
If the debt is going on for 50 years, then the guarantee is also going on for 50 years. No problem.
That is not the meaning of continuing guarantee.
What is the meaning of continuing guarantee then, sir? Sir, every continuing thing has to come. Everything has to have a life, sir.
Yes, sir. That I am telling. That I am agreeing with you, sir.
Correct. Because if the bank can't come, this is
yes.
After 100 years, they can say, "Oh, you gave me a guarantee. Your father gave me a guarantee. Now you are the legal heir."
Sir, one more thing, sir.
Simple.
As long as in the personal guarantee case,
yes, sir.
RPs are doing correct, sir. Whatever the lacunas are there with the bankers only, sir. Bankers are that I am a banker, sir. I am telling. I am a banker, true banker, 35 years. What generally happening, they are not having the proper record. We are doing a dual role.
I agree, sir. I agree.
Sir,
good evening, sir.
As that of this SimplEase for PG to CD, is there any such kind of thing for CRP also?
Sir, transition team A is going forward and they are now creating a software for bankruptcy first. Then already their team is working. They are going backwards to CIRP and liquidation and voluntary liquidation. So it will take time, but it will come, sir. Don't worry. And that will be a fantastic. And use this, sir, SimplEase for personal guarantors. You will find it absolutely perfect. Nobody has to lift their little finger. Everything will be at the click of the button.
And how secure it is, sir?
Sorry?
How secure it is? We are sharing the information of the parties to the
complete secure data. No worries on that account.
Verified one.
Absolutely secured, sir. You can check that security. There is a security certificate which is there. Don't worry, sir. I mean, everyone.
Good evening, sir.
Yes, good evening. Yes, sir.
Sorry, please bear me with my bad throat, sir.
No worries, sir. No, go on, sir. To wind up now. Just go ahead, yeah.
Sir, in one of my case, there is a joint loans taken by husband and wife, and husband has filed for the PG. Okay. And in one scenario, he is the property owner. In other scenario, the wife is the property owner. In both the cases, how to adjust about the joint loan obtained?
No, the point is, if there is a joint loan, then both of them are defaulters.
Yes, sir. Both of them are defaulters.
Who had given guarantee? So
husband is a PG. Husband has given a guarantee in corporate concern, and this loans was taken as a personal capacity.
I'm sorry, I've not understood. So he has given.
For example, AB husband, Mr. A husband is a director in ABC Limited.
Ankur, let's do one thing. Can you call me personally? Let's discuss offline because there are a lot of issues.
No.
Let's wind up here. You can call me. You have my number, no? Yes. You call me. We'll discuss, right?
Thank you.
Okay, friends. So thank you so much for patiently hearing. And I think there have been a very, very large attendance today. I'm so delighted, and I must also thank the team. Right, all the team members have worked very hard to bring this to fruition. Okay. Yes, over to you, Brindaji.
Yeah. Thank you, sir. So on behalf of IPNet, it is my privilege to extend our heartfelt gratitude to our esteemed lead speaker, Dr. Ashish Makhija, and our wonderful moderator, Rashmi Chaucharia, for their invaluable contributions today. Dr. Makhija, your deep expertise and immense efforts in demystifying the complexities of managing personal insolvency, along with the detailed process and templates, keeping in view the importance of maintaining timelines and ensuring compliances through SimplEase, were truly remarkable. Your detailed insights on the limitations on personal insolvency in IBC with Supreme Court judgments and the resolution professionals' responsibility on the same were invaluable. Rashmi Chaucharia, your seamless moderation kept the session engaging and ensured a meaningful and insightful dialogue for all of us. As a token of our appreciation, we are honored to present this memento as a small gesture of our gratitude. We sincerely appreciate your time, effort, and dedication in making this session a resourcing success. So we are sharing the memento.
Thank you, Brinda. I think we can just go ahead. Thank you. Thank you.
Your
Thank you.
contribution is invaluable. So I think the certificate of appreciation is well earned. Okay.
Thank you. Thank you. Thank you.
Okay, great.
So,
Thank you.
Thank you, Rashmi Chaucharia. Thank you once again. So now I invite Mr. Rajiv K. Agarwala to announce next webinar by IPNet.
On behalf of Rajiv ji, I am on behalf of IP NIST, 9 East. We are delighted to invite you to our upcoming webinar on 22nd February 2025 from 4 p.m. to 6 p.m. The topic is effective stress management strategies in CRP or liquidation. And the esteemed speaker will be our own IPNet member, Mr. Jitendra Lohia from Kolkata. Please join us for an insightful session where we will explore practical approaches to managing stress effectively during CRP or liquidation. Thank you. Stay tuned. We'll share the details shortly. Thank you.
I think, friends, it's a fantastic topic which has been decided by the IPNet East team. Stress management, right? All of us are very stressful, isn't it? How to manage that stress while performing our CRP and liquidation function. I think you must attend. It's a must attend webinar. Thank you. Okay.
Thank you.
So now I invite Suhasini Ashobi for vote of thanks.
Thank you, sir. Thank you very much for your insightful thoughts and your interpretation on the various critical aspects of personal insolvency. I just want to share one of my experience. Sir takes master classes in each processes. So I was the first group participant in the master class of personal insolvency. That was during COVID period, and sir has extensively interpreted when the personal insolvency was notified, and he has shared all the material when I attended the master class. And fortunately, in our IPE in India, that was the first few cases where before this Lalit case was admitted in the Supreme Court, some PG matters were admitted, and I was able to handle the personal insolvency process very confidently. After I attended the master class of Ashish Makhija sir, I was the first beneficiary, I can say, of his master class, and I'm very happy that sir has introduced this SimplEase, and this is a trending area now in IBC. Lot of personal insolvency cases are getting admitted. Personally, I have 8 cases, so I look forward to subscribe for this software, sir, and also look forward for your next bankruptcy software, sir.
Yeah,
Thank you
definitely.
very much for making the process very easy for us.
Thank you. Thank you. And I think we must thank all the participants.
And thanks, sir. Yeah, thank you for thanks to all the participants for engaging actively, and also taking advice from expert sir, Ashish Makhija sir. I can say he's amazingly expert in personal insolvency.
I'm not an expert.
I always look forward to sir whenever I have very critical issues in either CIRP or personal insolvency or voluntary liquidations.
No, I think it's your greatness you are saying this. I am only as a member of the fraternity, and I share what I know. And I think I also get enriched by contributions by all the members. Thank you so much, and have a wonderful day. Thank you. Thank
Yeah,
you.
happy weekend. Yeah.